Your Honor.
This form will be made part of your court file. You understand that if you plead guilty today, you will waive the rights listed on this form because you would not have a trial of any kind.
Yes, Your Honor.
Are you on probation or parole for any offenses today?
No, Your Honor.
Has anyone made any promises to you to get you to plead guilty today that we have not talked about on the record today?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty today?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
Understanding the maximum possible penalties and the rights you are giving up, how do you plead to attempt resisting obstructing a police officer?
Guilty.
Understanding the maximum possible penalties and the rights you are giving up, how do you plead to domestic violence?
Guilty.
Okay, Mr. Duckworth, I am going to take you back to August 16, 2016. Were you in Davidson Township, Genesee County, State of Michigan?
Yes, Your Honor.
Your Honor, would you like me to inquire?
Sure.
Mr. Duckworth, on August 16th in Davidson Township in Genesee County, Michigan, did you have an altercation with your wife?
Yes.
Was it an argument and then it turned into a shoving match, is that correct?
Yes.
And later were the police involved?
Yes.
And when the police went to arrest you, did you pull away and not comply with their initial request?
Yes.
And did they have to actually forcibly pull your hands behind you to arrest you that day?
Yes.
I think that meets the minimum requirements, Judge.
I would agree.
Any questions?
No, Your Honor.
All right, I do find a factual basis, Mr. Duckworth, to accept your plea. I will accept your plea to attempt resisting obstructing a police officer. However, on the domestic violence, you did state that Maria Duckworth is your spouse. Is that correct?
That's correct.
Yes, Your Honor.
Okay, and you have testified that there was a verbal altercation that turned into a shout.
Shoving match. There was physical contact, Judge.
I thought you said shout.
No,
Okay.
shoving. They did have
Mr.
to.
Duckworth, did you place your hands on your wife?
Yes.
And did you shove your wife?
Yes.
Okay. Based upon that, I also find a factual basis to accept your plea to domestic violence under the understanding that the people are recommending that the court accept that under 769.4A. I have signed the dismissal for count 2, resisting and obstructing a police officer. Okay, I am going to order a pre-sentence investigation report, Mr. Duckworth. We're going to do paperwork and you're going to go across the hall and set an appointment for a probation officer who's going to interview and make a recommendation to the court of appropriate sentence. Okay? And you do have the recommendation from the prosecutor of no jail. They need about 6 weeks, so I am going to set your next date for Mr. Christensen. Does October 26th at 9 a.m. work for your schedule?
Yep, that should be fine, Judge.
Okay, sentencing will be October 26th, 2016 at 9 a.m. Anything further, Mr. Thomas? Anything further, Mr. Thomas? Anything further, Mr. Christensen?
No, Judge, thank you.
Thank you, Mr. Christensen.
Thank you, Judge.
What's your name, sir? Okay, call case number STO 1356, People versus Alfonso McCoy. You're fine right there.
What's his name, Judge?
Is that Mr.
McCoy.
McCoy?
Alfonso?
Your last name is spelled M-C-G-A-U-G-H-Y? Okay. Okay, Mr. McCoy, today is the date and time set for your preliminary examination. Mr. Tomaszewski appears. And Mr. McCoy, you had stated at your arraignment that you were able to hire an attorney. Have you hired an attorney, sir?
It was for a separate case, and I didn't.
Okay, so you were able, maybe someone was going to retain
I thought
someone.
it was already all tied together, and it's not.
And it's not. So
Your
are
Honor,
you able to?
I spoke with Mr. Scott this morning because a note in my file indicated they retained Mr. Scott. He said that he was retained on a probation violation, but not on this underlying charge. I have him as Jamal McGoffey, though. Or what's the name on the
Alfonso Dwayne McGuffey, is that correct? And what's your date of birth, sir?
6/27/1982.
And that is what I see on the ticket, on the free bail, and on everything, Mr. Thomas. So I'll let you look at the court file. Okay, Mr.
McGoy.
McGoy. Are you requesting the court appointed attorney for you?
Yeah, I guess.
Okay. The court, Mr. Tomaszewski.
No objection.
All right, the court will appoint an attorney, Mr. McGoy, and you will now have your preliminary examination. I'm signing the order, Mr. McCoy, and what's gonna have to happen is this has to be faxed, and it will be done right now, but the probable cause conference will be tomorrow, and that is not enough time. So, your probable cause conference will be Mr. McCoy, are you being held under probation violation?
Yes.
Okay, when's your next date?
On the 16th. I actually have 16th on the 16th.
16th of September?
Yep, and, on the 3rd.
Okay. All right, your probable cause conference will be September 15th, 2016. And we'll, have that be your probable cause conference. Your court appointed attorney will be here on that day. It's gonna be before your probation violation sentence, because they may ask for an additional adjournment on that, but, that is your next day.
Okay.
All right, thank you. Okay, Attorney Flood, are you and the defense attorneys ready for me
Right.
to call the probable cause conference?
Right, Judge, yes, we are. If you want, we can have it so we call the DEQ defendants first, and then the DHHS defendants second. Or if you want to do them all at the same time, it's up to you. And Judge, very first note, Mr. Harrison with Defendant Glasgow is just here for a control date, and that could be really quick.
All right, I will call that.
Yeah, thank
All
you.
right, call case number 116-C0927-FY, People versus Michael Glasgow.
Good morning, Your Honor. Robert Harrison, appearing on behalf of Mr. Glasgow, who is right here.
Okay, today is the date and time set for a review date. How would you like to proceed?
Good morning, Judge. Todd Flood on behalf of the people. Judge, Mr. Glasgow has met with us on multiple occasions, and we've been in constant contact with Mr. Harrison. He's complying so far with the plea agreement and the orders of the court and the agreement of the plea. So we'd like to set it up for another control date, Judge.
Okay.
I agree with everything Mr. Flood said.
Okay, what would be a realistic time frame? And I know I was handed a handwritten note on potential preliminary exam date.
Whatever works for the court.
How far do you wish to go out?
60 days, if that
60
puts
days?
us,
Okay.
whatever works for Mr. Harrison as well.
Mr. Harrison, I'm looking, if we're in that time frame for just a review date, the week of November 14th, does that work?
Your Honor, I'm starting a 4 to 6 week trial in federal court on the 8th of November.
Okay, we
You
will
wanna do
not
something
go to
early?
November then. Would you like to go before or after your trial?
I would think that, you know, I think I'd rather go after, Your Honor. Perhaps the 14th or 15th of December.
It's fine with us, Judge.
Okay, let's set that as the next date for December 14th, 2016. And is 10 o'clock a good time?
Yes, Your Honor.
All right, at
Thank you very much.
for the next review day.
Thank you, Judge.
Thank you.
Anything further?
No, Your Honor.
Nothing by the people.
Okay, thank you both.
Thank you. Okay, Ted. See you.
Thanks, buddy.
Attorney Harrison?
Robert Scott, 16T.
Robert Scott's with the DHHS.
I apologize.
That's okay. That's okay.
I am not going off the record on that file.
Okay.
16TB 1685 FY People versus Leanne Schechter Smith. Call case number 16TD 1685 FY People versus Nancy Peeler.
No, that's Judge Cheryl Gorwitz. That's MDHHS.
I'm going off the record on that file. Call case number 16TC 1685 FY People versus Patrick Cook. And are those all the?
The Judge Steve Bush, defendant Mr. Bush, and Mr.
Okay.
Prisby.
All right. Call case number 16TB 927 FY People versus Michael Prisby. Call case number 16TA 927 FY People versus Stephen Bush.
Thank you. Todd Flood on behalf of the people, Judge, along with Mr. Dawson.
Your Honor, James Burdick on behalf of Mr. Rosenthal, and we waive his appearance.
Okay, good.
John Smetanka, representing Patrick Cook.
May it please the court, Frank Reynolds and Richard Hillman representing Mr. Prisby, who's sitting in the back of the courtroom.
Okay, good morning.
Good morning, Your Honor. Mark Krieger on behalf of Stephen Bush, and the last time we were here, I waived his presence.
Okay, good morning.
Good morning, Your Honor. I'm Brian Morley on behalf of Ms. Schechter Smith.
Okay, good morning to you all. Today is the date and time set for a probable cause conference. So my first question is always, has Mr. Attorney Flood, have you had an opportunity to conduct your probable cause conference with all the defendants?
I have, Judge. We are in the process of giving all the defendants that don't have exhibit books to put that work together for them. We have spoken at length as it relates to dates, Judge, and I wrote out a handwritten note for you as it relates to the dates for the probable cause conference. What we've come up with to date is, if it works for the court, and obviously the court, we're at your deference, Judge, whatever you like. Control date for a pretrial would be 1/18/2017 at 1 o'clock, and an exam date of March 13th at 10 o'clock. The exam date
Monday, March 13th.
Monday, March 13th at 10 o'clock, and the exam for the people, Judge, realistically would take 3 days on the DEQ side. Adding 5 lawyers, 6 lawyers in this case for the defense, it may go an extra couple days. So I looked at 5 days for the court, so if that works.
Okay. Anyone for any of the defendants wish to speak as to the date? Both the control date of January 18th, 2017 and the March exam date, March 13th, 2017.
Yes, Your Honor.
Okay.
I spoke, Mr. Flood raised the issue of whether any of the defendants would be prepared to go earlier by him or herself, and we are prepared to go earlier, and we would be prepared to go in mid-January. We could do it January 18th, the day of the probable cause conference, if the court is open to that suggestion.
Okay. Attorney Flood.
Judge, due to the scheduling of witnesses and bringing them up, I proposed that possible thought with anyone to see if it might be a viable option. I don't want to do the exam, have people from around the country come up here multiple times if I don't have to. That being said, Judge, I'd like to talk to Mr. Krieger to see within the next week or so if that actually makes viable sense for both sides. Otherwise, we'd have Mr. Krieger go with the rest.
Your Honor, if Mr. Flood is agreeable to going separately on Mr. Bush, and I think Mr. Prisby, although I shouldn't speak for Mr. Reynolds, might be willing to also do that, would the court be agreeable to that?
I would certainly listen to arguments on both sides, and I would certainly listen to
Right.
there was a substantial hardship on bringing the witnesses in from other parts of the country. Again, I don't know how many witnesses we're talking about. I don't know the location of the witnesses, but the court is willing to do that. If both parties certainly agree, the court is willing to do that. If there's not an agreement, then I will listen to arguments.
Thank you, Your Honor.
It's my idea, Judge, to try to go earlier. That's what I was hoping to do, so for the people, to move it earlier. And the issue is there's been more discovery that has come out that Mr. Krieger just received. He can't go now, schedule it now because he just received that. We're ready to go, but unfortunately, of the truncated process of rolling out some of this discovery, which is out of our hands.
May I please
somewhat
Frank
handcuffed.
Reynolds? We just received, in terms of the timing on everything that we're doing, we just received 309,000 pages of new discovery, and I'm advised that we've got another probably 250,000 pages coming. So there's a lot of discovery, and for some people, it's more of an issue. For those of us that have been in early on, we're ahead of the game a little bit.
And what's key to this, Judge, and you'll hear this later, so I'll tell you now, we have had to go to an outside source for e-discovery, and we've found, and we're helping the defense in this, we've found that 60% of the documents for which we receive are duplicates. So I get one email, and that email may be produced 16 times in my discovery. So if you get 360,000 pages, 60% of that being duplicative work is a waste. We're trying to help make sure that for what the special counsel office is receiving, to make sure that the defense counsel is not getting all the duplicates. So understanding that issue. So to Mr. Reynolds' point, he's accurate. He just did receive that, and that's why we're also putting together for them, and I have one for the court as well, the exhibit books for the anticipated, so we can streamline it, exhibits, emails that we're going to be putting as evidence.
And as the court is well aware, a lot of this is duplicated material. The problem is we have to look at it.
Figure out if it is
That's
duplicated
exactly correct.
material or not. I certainly understand that. So as of right now, I am stating that this court would be willing to do the earlier preliminary examination. If both parties request that, that will be done.
Thank you.
If that is not both parties, I will hear arguments as to both for and against doing a separate preliminary examination for, and it's only for Mr. Bush and Mr. Frisbee, is that correct? As of right now?
Yes.
That's great, Judge. Thank you.
Okay, so as we speak for the next date, however, as of today, our next date will be a control date of January 18, 2017. Is that correct?
That's accurate,
Correct,
Judge.
Your Honor.
Okay. Okay, now does anybody else or the defense wish to speak as to the date for the control date or the date for the preliminary examination?
No, Your Honor.
Is everybody in agreement with those dates?
Yes, Your Honor.
Yes, Your Honor, we are.
Yes, sir.
Yes.
Okay, so the control date for the next pretrial, January 18, 2017, preliminary examination will start March 13, 2017. Now I know everyone's coming, what time would you like to start? There's drive time.
Yeah, speak to that.
Yes, Mr. Flood graciously has acknowledged I've got a 3.5, 4-hour drive from my place, and so that's why it would be really nice if we could do it 1 p.m.
1 p.m.?
Yes, ma'am.
And
Now, if there's a prelim, then obviously it's going to be 3 or 4 or 5 days, we would just live here, but just for the...
We will definitely do, our control date will definitely be at 1 p.m.
Thank you.
And does it make sense for the first day of the preliminary examination, the first day to start at 1 p.m.?
I think we could probably start earlier than that. We could probably start at 10, couldn't we?
Is that fine for everybody?
10
Yeah,
10 o'clock, Judge.
We'll start at 10 o'clock for the preliminary examination.
I'm looking for a recommendation as to a motel.
Okay, I'm sure. And there are plenty of nice motels, I'm sure. Okay, anything further?
Judge, there is, I think Mr. Morley has an issue that I just was apprised of a moment ago as it relates to the protective order. And
Morley, if you could again tell me who your client is there. Your name is not on it.
Yes, Your Honor. I'm Brian Morley on behalf of Leanne Schechter-Smith.
Okay,
Judge,
thank you.
candidly, I'm catching you a little unawares. I don't know if you want a motion. There has been a protective order sent out by prosecution in this matter addressing discovery. In relevant part to a concern that I have, the proposed protective order says, further, the above materials may be disclosed to any defendant, witness, expert witness, investigator, or consultant engaged by either the prosecution or the defense in connection with this case. The concern that I have, Your Honor, is that the law firm with which I work is also handling a civil matter, several civil matters, and I don't know of anything that prohibits sharing of discovery within a law firm. I've never heard of having to create any type of ethical or Chinese wall relating to criminal discovery versus civil discovery. So that's one argument. The other, and I'll be candid because I've talked to Mr. Dawson about this, I'm a little bit concerned about an inadvertent disclosure. If I'm chatting with a coworker involved in the civil matter, hey, did you see that one memo, for example? Mr. Dawson has assured me, and I have no reason to doubt his integrity, that we're not concerned about that. With that said, and like I said, my bigger concern is more, I don't think it's appropriate to hamstring discovery within a law firm. And if need be, the civil attorneys can be brought into and encompassed within this protective order.
Okay, so so I understand, you have, and I have just been handed this protective order as well, and it probably reads the same as the other one, but I have not reviewed this protective order. Is your objection only as to that?
Yes, and that's it, and candidly, counsel, with everybody, I think we've been working on this nice and amicably. This is kind of a last minute, and it's the language in this case, and define the case or define what this case means is what it boils down to.
Judge, the law's, the law's well settled. I mean, we just had this very motion, and I do have a problem with not setting up Chinese walls. We just had this motion in front of Judge Kenny where it was public, and he kicked off a firm and representing multiple witnesses, both civil and criminal. So they're no longer allowed to represent, as we did our investigation, on multiple defendants / witnesses. This is, in criminal law, Judge, here investigative subpoenas are protected. There is no way that I could foresee, or any prosecutor's office, allowing these investigative subpoenas to be shot across the civil discovery realm. And those, that's sacrosanct within our process. I can't tell you how many different violations there are with that, because there's several, ethical and legal. As it relates to multiple civil matters, if the firm is representing multiple civil matters and potentially multiple criminal defendants, then there could be issues with conflicts. How do you, and witnesses. Well, you put a witness up on the stand, and by the way, you represent the witness, and over here you're representing the defendant. You can see, obviously, that play out with the conflict. Just from a remedial standpoint, I would like to talk to Mr. Morley more at length, but what this is going to do right now, and I just got done, and I came into this today not knowing any of this issue. I just have, and I think all the defense attorneys, both on the HHS and MDEQ, will tell you I'm doing everything I can to make sure they get everything, even things that they wouldn't have a right to get right away. So I'd like to talk to Mr. Morley, see if there is something here that I'm missing, and address it to the court at a later time. It's going to hold off right now, though, from me giving out any investigative subpoenas, any transcripts, any discovery, until we're all on the same page.
Okay, Mr. Morley.
Just so the record's clear, I said I've been discussing this with co-counsel. I also said if we amend this or modify it attorneys within our law firm will be subject to this protective order. So the remedial primer on whether or not this is going to be sent out through the civil discovery is not what I said. This is an internal firm matter. I also said through all of this that I've been cooperative with counsel. So if there's any suggestion in front of the court that we probably can't work this out, it's inaccurate. That's why I said I don't know that it's in front of you properly now. If we can't work it out, maybe I file a motion. So I guess I would ask, based on the dissertation, that the court would hold or be prepared, if necessary, to address a motion on this issue.
Yeah, the issue's going to be secrets, and that's the problem, because I don't know what witnesses they represent, and I don't know what plaintiffs. So that's why I'm saying this is a little bit more complicated than just saying, and I'm not disrespecting Mr. Morley. His reputation precedes him as a great lawyer and a great advocate. I have not spoken to him. Mr. Dawson has. I simply was given this today, and that's my immediate reaction to this issue. So I'm not here to play light on it, but this is a matter that I think we need to flesh out, and I said I would talk to Mr. Morley to see if we can resolve it.
Okay, so what I am finding is that I do not have a stipulated protective order in front of me. And that's the only thing I'm finding.
As it relates.
Mr. Morley.
Right.
And it is the court's suggestion that Attorney Flood and Attorney Morley talk about the language in the order, and if there can be an agreement, great, of course. If not, then a motion to the court, I believe, would be appropriate.
I'd like to clarify something, Your Honor, from what Mr. Flood said, if I heard him correctly. Those of us that have agreed to a protective order should be receiving these investigative subpoena summaries.
Well,
I thought he said, unless everybody's on board, nobody gets it.
well, the issue is this. I don't know who's sharing. If you have an investigator that's working in conjunction with each other, investigators, I don't know. If there's joint defense agreements, I don't know. Those things are typical in federal and state practice to use. And so I need to find out. I think this should be relatively simple, and we could probably wrap it up quickly. But I don't want to breach any ethical violations.
Well, either we're all in or none of us are in, and I guess that's the question that I have. We've already agreed to a protective order.
Right.
Well, then I would ask Judge that they, at this time, not, if there is some sort of agreements, that they're not sharing this at this time with Mr. Morley until we resolve that issue.
No problem.
No problem. On behalf of Steve Bush, Your Honor, I agree to that.
And
For
I
the
would,
record, Your Honor, Mr. Morley has already received a lot of discovery. So, just so it's out there.
Okay,
Yeah,
I have
but-
no objection to that, Your Honor.
Neither do I, Your Honor.
okay. Thank you, Judge.
Okay, so,
There is one other issue that Mr. Flood raised. It's my understanding that you were given that material to look at in camera, that Mr. Flood does not, from the Michigan State Police investigation, and that the court was going to make a decision on whether to release that, and that's still open.
I am in receipt of a binder. I'm also in receipt of a disc. I have not put the disc in a computer because I'm not sure if it's additional information on the disc or if it's the same information that has been printed out. There is a lot of information. I do not have, I have the in-camera review order. I do not have motions on either side of